For the People, Popular Sovereignty and the Power to Choose a Government by Elizabeth Ann Reese. The full text of this article may be downloaded by clicking on the PDF link. To protect state sovereignty, contemporary textualism has reinvigorated the 10th Amendment as a judicially enforceable limit on federal power. However, in casting the 10th Amendment as the states' rights amendment, these textualists have inexplicably glossed over the 10th Amendment's final four words, which reserve powers to the people. This article highlights this inconsistency and argues that this omission ignores a vital structural protection against federal and state tyranny, viewed through the same textualism that reinvigorated state sovereignty. The 10th Amendment's final words cannot be redundant or superfluous, but rather define and protect the people as a sovereign body capable of wielding specific powers, particularly those powers that the Constitution places beyond the reach of our governments. Primarily, the 10th Amendment protects that power which is at the heart of popular sovereignty as well as the foundation of our republican form of government, which they call a democracy. The power of the people to choose their government. The 10th Amendment ought to protect popular sovereignty as it protects state sovereignty by serving as a source for robust judicial review of federal and state laws that infringe on popular sovereignty. Recognizing this overlooked portion of the 10th Amendment could alter current legal doctrines surrounding voting rights by treating free, fair, and accessible elections as a matter of competing sovereigns' powers rather than individual voting rights. By ignoring the people in the 10th Amendment, American jurisprudence has ignored a vital structural protection against federal and state tyranny and risked government-driven erosion of our great republic in America. The adversaries of the Constitution seem to have lost sight of the people altogether in their reasoning on this subject, and to have viewed these different establishments not only as mutual rivals and enemies, but as uncontrolled by any common superior in their efforts to usurp the authorities of each other. These gentlemen must here be reminded of their error. James Madison. When one wants to speak of the political laws of the United States, it is always with the dogma of the sovereignty of the people that one must begin. Alexis de Tocqueville. Introduction. We the people, all right? People being singular or plural, are the source of law for the United States Constitution. Remember, in order to make the law, there must be a superior who can create it and an inferior who is bound by it. That's what we call the law of the land. The people created a more perfect union, ladies and gentlemen, and created these documents to bind the government servants so they would not encroach upon our unalienable rights. Are the source of the law for the United States Constitution that we the people have power over our own destinies was the driving ideological force behind the American Revolution. The founding of our nation and the Constitution that now binds it, we the people devised a system of republican government that would represent us instead of rule us. Popular sovereignty, broadly speaking, the right of the people to make laws and be ruled by them, is enshrined in our republic. And yet, we the people are absent from structural balance of power debates in modern constitutional law. Much of the modern resurgence of federalism, did I make a mistake? Feudalism, federalism, can be credited to a textualist reading of the 10th Amendment. Once treated as merely a truism, the 10th Amendment now protects state sovereignty as a judicially enforceable limit on federal powers. But the 10th Amendment does not refer exclusively to state sovereignty. Rather, it declares that the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states, respectively, or to the people. The most important part, to the people. The textualists that revived the 10th Amendment have quietly ignored this vital last phrase, where I ask, have the people gone, and what has become of our powers? In this article, I argue that ignoring the popular sovereignty provision of the 10th Amendment is not only inconsistent with the text, but also dangerous. Current doctrines improperly or insufficiently protects the exercise of the exclusive power that I identify as the heart of the people's power, the power to choose our government. In America, we have become accustomed to the idea of a right to vote, which belongs to each individual but can be burdened, greatly limited, or taken away by the state. In doing so, we dangerously treat a sovereign power whose legitimacy lies in mass collective exercise as an individual right. And we continue to not even see, let alone protect, the forest for the trees. If we do not recognize and safeguard those powers the Constitution reserves to the people as a separate sovereign body, there may be little to stop either state governments or the federal government from setting the rules by which they stay in power, and thus slowly eroding the democratic heart of our republic. The court's current interpretation of the 10th Amendment rests on the presumption that balancing powers between the state and a national government protect the people. But remember, this is a rebuttable presumption. As Justice Scalia explained, the power surrendered by the people is first divided between two distinct governments. Hence, security arises to the rights of the people. The different governments will control each other. This argument asks the people to trust that their interests will be protected by two admittedly power-hungry governments, or else trust that the state will be champions of the people by speaking for them as their closest representatives. Unfortunately, history, especially the Jim Crow South, has proven state governments are capable of doing quite the opposite, silencing their citizens in order to stay in power. In the pages that follow, I offer several arguments for how the 10th Amendment preserves the separate powers of the people. The most central is a textual argument. The 10th Amendment explicitly mentions the powers of the people separately. It says power not delegated are reserved to the states or the people. It does not say the remaining powers are to be reserved to the people through the states, or that they are to be reserved to the state and the people. Nowhere does the text suggest that the powers of the people are somehow part of or even lesser than the powers of the state government. Furthermore, the text of the 10th Amendment does not describe the powers wielded by the United States government as powers the people surrendered or relinquished. It describes those powers as delegated, which means if we delegate them, we can turn around and undelegate them, or do a rescission or a revision, and we can restructure. And all delegated power must be anchored to another political body capable of revoking it. Additionally, ignoring the people in the text of the 10th Amendment would be inconsistent with canons of textual interpretation. If we accept the assumption, remember assumptions and presumptions, they're always rebuttable, as many have suggested, that the Constitution anticipates that the voice of and the powers of the people are synonymous with the state or states. The last four words would be superfluous. Such superfluity is entirely inconsistent with the court's current reading of the Ninth Amendment, in which the rights retained by the people resoundingly communicate to the government. Go this far, but no farther. The 10th Amendment's popular sovereignty provision may mean many things, but it certainly means more than the court currently recognizes. In the 10th Amendment and throughout the rest of the Constitution are explicit indications that there are some powers neither the state nor the federal government can wield, and those powers must belong to the people. Democracy and popular sovereignty are not only values enshrined in our republic, they are structures set into our Constitution. In short, the 10th Amendment defines federalism or feudalism as a delicate balance not between two sovereigns, but three. I challenge constitutional law scholars and practitioners to reconsider the substantive power of the last four words of the 10th Amendment. I argue that the 10th Amendment defines the people as a body that is capable of retaining and required to wield sovereign powers that are distinct from the powers of our sovereign governments. As such, the 10th Amendment should no longer be exclusively synonymous with states' rights. Rather, it is time we reinvigorate the 10th Amendment as a protection of popular sovereignty. What appears to be the primary barrier to taking the popular sovereignty provision of the 10th Amendment seriously is the assumption that the sovereign boundaries delineated by the Constitution and policed by the 10th Amendment are absolute and therefore cannot overlap. While there are some generally accepted areas of concurrent sovereign authority not expressly delegated by the Constitution, criminal punishment, for example, when discussing the limits of sovereign powers, the court traditionally relies on a model of non overlapping powers. Competing sovereignty is usually an external limit. Where the sovereignty of one government begins, the sovereignty of the other ends. Even when the boundaries of sovereign powers are unclear, such as the limits of the Commerce Clause or federal preemptions, the court usually treats these cases as a discovery or assertion of the limits of sovereign powers. The logic usually being that the Constitution placed powers with one group or another, full stop. As a consequence, the court has historically been very resistant to the continued overlap of sovereign authority. This general resistance to recognize the Constitution as creating a system of overlapping powers creates a unique challenge for popular sovereignty. It is difficult to imagine how the people retain any non-overlapping powers as a separate sovereign. Indeed, other than the power to abolish government through uprising, what powers do the people have that none of their governments can touch, interfere with, or mediate? Without a judicial precedent for how to negotiate overlapping sovereign powers, it is very difficult, though not impossible, for courts to devise appropriate tests to determine and enforce these boundaries. However, we are presently much closer to an enforceable popular sovereignty because of the recent accommodations doctrine put forward in United States versus Comstock. The court's Comstock opinion acknowledged the continued overlap of state and federal sovereignty and implements a test to ensure mutual respect and caution. Comstock's holdings that federal lawmaking is constitutionally permissible under the 10th Amendment if it appropriately accommodates or accounts for a state's sovereign interest, could easily carry over into popular sovereignty. The federal government and the state could be required by the 10th Amendment to consider and accommodate the sovereign interest of the people when legislating. If either a state or a federal government fails to accommodate popular sovereignty and chooses to transgress upon the powers reserved to the people, a court would be required to strike down that law as unconstitutional. Arguably, the federal judiciary already accommodates popular sovereignty by refraining from answering questions best left to the people under the political question doctrine. Furthermore, under the theory of popular constitutionalism, many scholars have argued that social movements and changes in public sentiment affect the constitutional interpretations made by courts, legislators, and executives. A difference to the power of the people to shape and interpret constitutional meaning, in addition to providing a constitutional home for the political question doctrine and popular constitutionalism. A popular sovereignty 10th Amendment would robustly protect the power of the people to independently exercise our most fundamental sovereign power, the power to choose our government. Courts could more aggressively prevent the states and the federal government from interfering with the right to vote, thereby preventing either sovereign from the frightening tyranny of setting the rules by which they stay in power. While this article may present a novel idea, it should not be controversial. As the court stated recently in Arizona State Legislator versus Arizona Independent Redistricting Commission, popular sovereignty is the animating principle of our Constitution. The text of the 10th Amendment recognizes and protects popular sovereignty as one means of preventing government tyranny. Given the fear of tyranny and the veneration of democracy enshrined in our founding, it should be unfathomable that in the 20th century, the people's rights to vote was not and could not be robustly protected by the courts, such that Congress was forced to step in through the Voting Rights Act. And it is even more unfathomable that in the name of state sovereignty, the Supreme Court strike down portions of the Voting Rights Act, Voting Rights Act, which preemptively ensured that state governments could not systematically exclude part of their electorate. Pending now before the court in a case concerning partisanship, gerrymandering, which is at its heart about the ability of the people to properly be heard. Without recognizing the structural role of the people, the court will likely focus on the judicial utility of formulas rather than the adequate and appropriate function of the powers as they would if this were a federalism case. The final words of the 10th Amendment are structural protection for the democratic part of our democracy and republic. Through judicial review, the courts should rely on the 10th Amendment to robustly protect the power of the people to independently exercise our fundamental sovereign power to choose our government. Courts could look directly at questions of voter access and prevent the state and the federal government from eroding voter access when it suits them. The 10th Amendment guards the exclusive right of the collective American population to choose their government unencumbered. The Constitution protects the independent and free exercise of our great republic, which they call a democracy. Rather than fight a legal battle over the burden of individual rights, courts would police the boundary surrounding the free exercise of voting powers from interference by state and federal government. Instead of going to the court over specific prohibitions on certain voting laws, litigants could challenge whether any voting laws appropriately accommodate and preserve popular sovereignty. That is, whether they actually work to protect voters and increase voters' access. It is not merely the rights of individuals, but the sovereignty of the people that is denied by discriminatory voting laws. And it is through the constitutional protection of that sovereignty that courts should be required to strike those laws down. No government should set the rules by which it retains power. Voting should be accessible to the people, and how accessible should not be a policy choice that is left to the discretion of a government with a potentially competing agenda. Since the United States extended voting to more than just white men in the late 1800s, American voter turnout has hovered around 40 to 60%, one of the lowest in the developed world. Turnout is low, at least in part because Americans have accepted this reality that our government can make voting hard, or at least prohibitively inconvenient for the people, and that the people will in masses not participate. In Alabama, where the public battle for the Voting Rights Act was waged just over 50 years ago, the Alabama Secretary of State called automatic voter registration a sorry and lazy way out. While sometimes a government's motivation is voter suppression, other times it may be simply prioritizing what is more convenient or efficient for the government rather than what is convenient or accessible for the people. In either case, something has gone wrong with the way that we, the people, exercise our power in American democracy and the American Republic. Lower voter turnout and the court's continued struggle to decide election laws case under the Constitution in a manner that fully protects the rights to vote should serve as a wake-up call that the court has an incomplete picture of the sovereign power at stake. While the Constitution explicitly forbids denying the right to vote for specific reasons, characterizing voting as a fundamental right guaranteed only through the 14th Amendment does not fit the structural prominence that democracy has been afforded since the beginning of our republic. The 10th Amendment could provide the basis for a more robust protection of voting rights as exercise of sovereign power that demand aggressive judicial defense. The right to vote ought to be policed as a integral part of the republic's balance of power. This article proceeds in 4 parts. Part 1 being with a history of sovereignty and federalism in American law, specifically the cases involving the 10th Amendment. Much of the debate about the meaning of the 10th Amendment has relied exclusively on originalist arguments, despite intense scholarly disagreement about the sincerity of the Founding Fathers' belief in popular sovereignty and the original understanding of the 10th Amendment. In light of this disagreement, I emphasize the need for a textualist reading that reflects the words of the 10th Amendment as enacted. I then move through the court's long history of delineating sovereign powers and finding that popular sovereignty is a relatively recent disappearance. Not until the 1980s did the court begin quoting the 10th Amendment, but omitting the last 4 words and treating it as the States' Rights Amendment. Before the 1980s, popular sovereignty was at least sporadically mentioned along with state and federal sovereignty. In part 2, I present a textualist argument for a popular sovereignty 10th Amendment. I begin by discussing the potential for a new era of tri-party sovereignty in the court, including popular sovereignty, made possible by the court's decision in Comstock, which recognizes overlapping sovereign powers. Next, I describe how the text of the 10th Amendment and the rest of the Constitution clearly define and protect a distinct sphere of powers prohibited to the state and federal government, powers that necessarily remain with the people. Here I also consider the debate over who the people of the 10th Amendment are through fascinating, I find this debate ultimately irrelevant, since regardless of whether the people are a national collective or the people of the several states, their sovereign powers are not protected by the current state sovereignty forced interpretation of the 10th Amendment. Even if the people are the people of the several states, instead of a national collective, they are similarly susceptible to state government repression of their sovereign power to choose their government. I then return to the text of the Constitution, specifically the explicit limits on federal and state powers, to highlight a few of the powers the Constitution implies the people share with their government or retain exclusively. In part 3, I show how overlapping and dependent sovereignty should not be as innovative or challenging to implement as one might otherwise presume, since it has long been recognized in written political philosophy and in even other parts of American law, specifically in federal Indian law. By exploring how complicated sovereignty can be, I reveal how one-dimensional much of the court's discussions of it has been. The acknowledgement of overlapping sovereignty and development of accommodation doctrine in Comstock represents a long overdue evaluation in the understanding of sovereignty in American constitutional law. Finally, in part 4, I discuss how the 10th Amendment could require courts to robustly police the boundaries of popular sovereignty and strike down laws which burden voter access, and mention, albeit very briefly, other potential uses for this doctrine based on other powers that the people might have. When we come back, we'll be delving into the history.